Welcome to Penn State Dickinson Law's Profiles in Leadership series. My name is Daryl Lim. I serve as the H. Laddie Montauk Junior Chair and Associate Dean for Research and Innovation at the Law School. This series offers an unparalleled opportunity to glean insights from top leaders who serve in government, education, the private sector, and civil society. In each episode, we invite these leaders to reflect on their journeys and share skills, core values, and qualities that make them the leaders they are today. We're very pleased to have Professor Spencer Weaver-Waller. Spencer is the John Paul Stevens Chair in Competition Law and Director of the Institute for Consumer Antitrust Studies and Professor at Loyola University Chicago School of Law. He teaches antitrust, intellectual property, civil procedure, and international litigation courses. He is a member of the American Antitrust Institute Advisory Board of the American Antitrust Institute, beg your pardon, is a member of the American Law Institute and Advisory Board, member of the American Antitrust Institute, as well as the editorial boards of the Antitrust Law Journal, World Competition Law and Economics Review, and other scholarly journals. Professor Waller is the author, co-author, or editor of 8 books and over 100 articles on U.S. and international antitrust law, including Antitrust and American Business Abroad, the leading treatise in the field, and the first full-length biography of Thurman Arnold, the founder of modern antitrust enforcement in the United States. Professor Waller previously taught and served as Associate Dean at Brooklyn Law School. In 2022, he served as Senior Direct Advisor to Federal Trade Commission Chair Nina Khan. Welcome, Spencer.
Thank you, Daryl. It's great to be here.
Now let's start with your professional journey. What was your path to being a professor like after you graduated from law school?
Yep. I grew up in Chicago, and I went to college at the University of Michigan, and I came back to Chicago to go to Northwestern Law School. When I graduated law school, I had no particular, I didn't know very much about what it was to be a law professor or how you got a job doing that. And so I did other things. I practiced law for 8 years, and I spent 1 year as a law clerk at the U.S. Court of Appeals for the Seventh Circuit, which is the federal appellate court covering all federal cases for Illinois, Indiana, and Wisconsin. And after that, I went to work for the Justice Department, the United States Justice Department, for 4 years, 2 of which I did antitrust litigation, most of it having to do with international commerce in one way or another. And this happened to be in the 1980s during the Reagan administration, time of very conservative, Republican, laissez-faire kind of policies. Business was slow in the antitrust area. I wanted to get some litigation experience that just wasn't going to happen. As much as I enjoyed working on the kind of cases that we had, we could talk about it if that's of interest to you. After about 2 years, I switched within the Justice Department from antitrust to what's called the Organized Crime Task Strike Force. And I was sent back to Chicago happily to work in the Organized Crime Strike Force of what's now is part of the U.S. Attorney's Office. It was slightly separate at the time. And so for 2 years, I was a federal prosecutor doing basically mafia cases in Chicago, which was not a politicized thing. The Reagan administration was just as hard on organized crime as the predecessors and the successors. And I was just a trial lawyer. I was in front of a jury within 3 weeks. I never tried a jury case before that. I had appeared once or twice in court for the Antitrust Division. And I spent 2 years trying cases, arguing appeals, doing grand jury work. And after about 5 years with the government, I felt it was time. I had enjoyed my time in the public sector. I wanted to get some law firm experience. I also welcomed the chance to earn a private sector salary for a while. And I went to work for a small firm in Chicago, relatively small firm. I was the 15th lawyer when I joined the firm. I was about the 50th lawyer when I left a few years later. But I picked a firm that was gracious enough and honored every promise, but basically promised to treat me according to my experience, not merely the number of years since I had gone out to law school. So I didn't expect to be a partner. I joined as an associate. I didn't expect to, I didn't have any clients because I was a prosecutor, basically. The deal was I had tried some cases, I had argued some appeals, and I wanted to be treated accordingly. So what happened at this firm, and they were great, it was called Freeborn and Peters. It's since merged into an Atlanta-based firm called Smith, Gambrell, and Russell. But at Freeborn at the time, they gave me control of small cases and had me as the junior lawyer on bigger cases, usually on 2-person or possibly 3-person teams, because just weren't that many other people. And I worked there for 3 years. I tried cases. I argued a few appeals, some pro bono, some for clients, some under very stressful circumstances, like intervening in a case and being told my motion to intervene was granted, but the trial was set for 5 hours later, and by God, they weren't going to delay it just because we were a new party in the case, and things like that. And I had a great time. And I also got the urge to teach, the teaching bug. And while I was in the U.S. Attorney's Office and while I was at the firm, I taught as an adjunct at another school in Chicago called IIT, Chicago Kent College of Law. Taught a little seminar on international antitrust. I wrote a couple of articles here and there, consistent with, working hard at the firm and being responsible for other things. And I became a full-time professor in 1990, moved to New York City because I taught at Brooklyn Law School, and I worked there for 10 years. I was associate dean, and I had the chance to return to Chicago, city I love very much. At this point, I was married, and we had a small 4-year-old kid, and I liked New York just fine. It wasn't home for either me or my wife. I can tell you it's easier to raise a family in Chicago than it is in New York. If nothing else, you don't have to deal with the subways and baby strollers and that kind of thing. And I've been at Loyola since the summer of 2000. I've also been an associate dean here, but my primary role, my only role right now, is to teach Civ Pro in the fall, antitrust in the spring, and other courses as needed, and direct this Institute for Consumer Antitrust Studies, which we can talk about down the road. But that is the super long answer to a perfectly reasonable question of how I got here today.
Well, great answer. So much rich material, lots of questions. But before that, since you teased us with those cases that you worked on, why don't you just quickly walk us through some of those highlights?
While at the Justice Department, even at the Antitrust Division, while I wasn't trying cases, I did work on briefs and other things. The first, to my knowledge, the first pleading that ever had my name on it, I was one of like 11 lawyers who drafted a Supreme Court brief. And by drafted, I mean I wrote the first draft of one section that then got rewritten by all the different levels of people above me. But there's a case from the 1980s that you may teach in either civil procedure or antitrust called Matsushita. And it's a case both about summary judgment and predatory pricing, and whether or not there's an agreement when firms act in a similar way, but not necessarily by agreement. How much evidence do you need to get trial? And the government was not a party. The parties had been litigating for 16 years and had something like 13 and a half years of discovery. And the case was in front of the Supreme Court as to whether there was enough evidence of a conspiracy to warrant a trial. And the Supreme Court, as it often does, asked the government for its views. So this was the Department of Justice, essentially on behalf of no one, just arguing on a bunch of different issues. I wrote on an issue that was not even part of the Supreme Court's opinion in the case, but it was great. It was fun to be in the room, on a big case doing this. And then with the Organized Crime Strike Force, I worked on cases involving mob burglary rings, mob prostitution and escort service rings, insurance fraud, tax fraud, business fraud, loan sharking cases, drug dealing cases. Again, I was the most junior person in the office. Everyone else had years and years of prior prosecutorial experience. And I did maybe one case by myself, a very small matter that involved just a postal service employee who stole stuff from the mail that I just took on as an extra case to get litigation. A couple times I argued the appeal of a case where someone was convicted and obviously appealed their conviction. And that was the background I had when I came into private practice. And I argued and tried small matters myself. I was part of trial teams on bigger cases, only one of which happened to be antitrust. But I also worked pro bono for the Federal Defenders Panel, which assigns counsel to people who can't afford it, or outside lawyers where the federal defender has like one client and there's a conflict. There's another, say, defendant in the case. And I represented a lovely woman who was charged in a kind of a government benefits fraud case involving, as I remember, checks for some Department of Housing benefits program. She was the cashier at the currency exchange where many, but not all of the checks were processed. Government's theory is that she was knew it and benefited from it and just was part of this scam. And my theory was there was no proof of that beyond a reasonable doubt. And unfortunately, she was convicted. On the other hand, the judge recognized that either she really didn't have anything to do with this or barely had anything to do with this. And so she was only sentenced to 6 months of kind of like a halfway house where she could like work release, where she could continue to take care of her family and get on with her life after this. She got released after 4 or 5 months. So, I did a little bit of this, a little bit of that. And since becoming a law professor, other than doing a brief or two pro bono, because I don't really have time to litigate a case and do discovery or anything like that. Every once in a while, I have taken on a pro bono matter that either doesn't involve litigation through an organization called Lawyers for the Creative Arts that you may know is based in Chicago. As far as I know, it's based in Chicago. And occasionally I'd argued an appeal once or twice for a paying client and more often for a pro bono thing where either the court appointed me or someone asked me to get involved in a case where someone had been convicted or found liable in some civil case.
How did you learn to pick out so many different things quickly?
Oh, that's a great question. So I don't know your experience, but in my experience, private practice is fundamentally different than academia because you're generally speaking asked to do things on a budget and on a deadline. And there's, you're not going to commit malpractice. You're a good lawyer. You do the best job you can, but something has to happen, has to get out of the door by a certain period of time. There's either a deadline by the court, by the client, or by a partner, at your firm, especially when you're more junior person. And so you do the best job you can. You work evenings, you work some weekends. I don't think I ever billed more than 2,100 hours a year, but that still required bringing stuff home from the office. You'd get there early so you could get out at 6 or 7 o'clock, go home, eat dinner, finish up some light reading or some other stuff. And I'd go in maybe one weekend, day a week, or certainly every other week. And I still do. But the real difference is now when we work on an article or a book or a project, consistent with our other responsibilities and having a life, we put in as much time as we can on something that we chose because it's interesting until we get it right in whatever sense. That's just different than doing what's important to the client, whether or not it's interesting to you, and getting it out the door in a timely fashion. And, it's obviously a little more stressful in private practice. And they're paying you for putting you in these circumstances. But that's the main difference. And it's really a blessing to be able to teach stuff I like and pick projects to write about or get involved in the real world, which I don't do much of, because they mean something to me. And I've got some opinion or something to say or some empirical research project where I'm trying to make a difference in the real world. And obviously that doesn't get into the teaching side, which also gives me great pleasure. But, I work on a book or an article until I think it's done or I just can't stand looking at it anymore.
So I'm going to ask you about the difference that you make in the real world in just a moment. But one thing that struck me just looking at your background is how much time you spend in the Midwest. Certainly, your college at University of Michigan,
Hmm?
where you did econs and poli-sci is in the Midwest, and so was your law school at Northwestern. How do you think that shaped how you view the world?
That's a neat question. Yeah, I mean, I grew up in Chicago. I like it here. What you've noticed is a pattern is I've gone out and come back and gone out and come back. You're correct. Ann Arbor's in the Midwest. It's obviously not Chicago. It's about 250 miles. But I spent 2 years in Washington with the Justice Department until I transferred back to a different part of the Justice Department. I spent 10 years in New York teaching and getting married and having a family. Came back to Loyola. I've gone out on short visits at other law schools and some international teaching, coming back. I spent a year in Washington with the FTC, somewhat remote, somewhat in Washington, coming back to the law school. I like it here. I like big cities. New York is fine. Washington's fine. I prefer Chicago for a variety of reasons. It has much of the good things about New York, in my opinion, and less of the bad things. And that's a nice combination of things for me. And
Doesn't hurt to have an apartment where your elevator stops on the floor, right in front on your doorstep.
yeah, your dollars go a little bit further, particularly when we're on an academic pay scale, not on a private firm pay scale.
And listeners probably don't know this, but anybody that's been to Spencer's colloquium actually has the opportunity to visit. He very graciously opens up his house for reception. In fact, he's going to do that again this year. I
Yeah,
saw
we
the invitation.
for 24 years, Loyola has sponsored and I've directed a one-day seminar symposium that we call the Loyola Antitrust Colloquium, where we've gathered between 100, usually 150 people, combination of students and lawyers and judges and professors and economists and people from the US and people from other countries. And it's a day of presenting sort of cutting edge papers and having commentators and discussions. And then we usually have like a lunch keynote speaker who's usually a government person or occasionally a past government person. Last year, I think you were there, I don't recall. The chair of the FTC, Lena Khan, was gracious enough to do a lunch keynote. Now, given that she had a newborn of her own and runs an important government agency, she spoke remotely. But usually the person, the speaker, is present in person, and as part of this colloquium, and oftentimes comes to this general reception I have at my home the night before, so that the speakers are not sitting in a hotel room eating a crummy room service hamburger, and they get to meet each other and start the conversation. And it's a chance for my students to come and meet people in the profession, particularly if they're interested in antitrust and consumer protection, and have a conversation. And they want to network, that's fine. If they just want to better understand what the person's going to talk about the next day, that's great. And if they just want some free food before they go back to their apartments, I'm happy to give it to them and some leftovers.
I think that's really something that's wonderful and characteristic of the Midwest. I've probably been to more people's homes in my time in the Midwest than I've been just about any other part of the United States.
Well, since it's just the two of us talking, I stole the idea. I stole the idea from Bert Four and the American Antitrust Institute, where for a period of time when he was president of that organization, which is a progressive lobby group in Washington, organized around antitrust, he happened to have a very large home, much bigger than my apartment, beautiful home in Washington, D.C. As far as I know, he still has it. With like a swimming pool in the back, and he would have everybody for his annual conference over to his home. And I thought it was a lovely idea. And since, as you know, ideas cannot be copyrighted, only their expression, if there's a good idea, I'm happy to borrow it for a good cause. And people seem to enjoy it. And if it gives them a small incentive to come back and take the trouble to, fly here or drive here or take time out of their busy day to come over, I'm happy to do it. It's fun. I get a lot out of it. And it's a nice day and a half. And it's really become an event that gathers people who have all different views, but basically think that antitrust and consumer protection is really important and should be vigorously enforced. And that in general, the government and the private lawsuits don't do enough in that area. And we try to brainstorm and build a community of people to hopefully make some change in the real world as we're starting to talk about.
And boy, hasn't that changed. I want to read an excerpt from a press release that your university put out when you were appointed senior advisor at the FTC. So the press release said your appointment would, quote, move us closer to actualizing our renewed mission to dismantle systems of oppression and injustice. How have you worked towards that goal using antitrust during your time as senior advisor to Chair Khan?
Yeah, so a lot to unpack. Loyola has a very unique mission among law schools that I'm very proud to be part of. And it talks about, you can find it online, but it talks about, battling systemic racism and oppression and systems of subordination and, really trying to fight that stuff. And I work in areas of economic regulation or civil procedure. And it's not the only thing that I teach. When I teach civil procedure, it's a required first-year course. It's day one. It's literally when they walk in the door for law school. I have to help teach my students to be good lawyers, have to teach them how to be good law students, to just how to read a case, how to understand a statute, what is a federal rule of civil procedure, how do you make ethical decisions for lawyers. And I also try to build in how these seemingly neutral rules of procedure, just to talk about that course for a second, how that they oftentimes disadvantage people who don't have lawyers, people who are poor, people of color, and how it oftentimes, if you're not paying attention, sound like they're being neutral, but they're not. They're favoring oftentimes very powerful interests in society who are not on the good guy side, at least all the time. And in antitrust, which is about economic regulation and seeks to prohibit things like price fixing and monopolization and mergers that hurt the consumers and suppliers and labor and the world. Again, we have, it's an upper class course. This is an elective, but you can read these cases and you should read them carefully, and you got to know the rules, and you have to think about how they apply to new fact patterns. And you have to obviously take an exam at the end of the course. But again, it's a situation where are they being used to help people who lack power in our society, whether it's because of money, race, ethnicity, some combination, gender, or can they be used as a tool to help people or just beat up on them? And you have to be able to sort of see one step below the surface. You have to both be a good technical lawyer and see the broader societal ramifications. I can give you a super quick example. You probably teach this class, which is FTC versus Trial Lawyers Association. And a bunch of lawyers who in the 1980s accepted court-appointed criminal cases in the local courts of the District of Columbia. They were getting paid $20 an hour with a cap of like $1,000 for any case. And they're representing criminal defendants who have no money and can't be represented by the public defender's office because they're either too busy or there's some conflict to represent more than one defendant. And they're being paid like crap. And it was impossible for them to either make a living or to represent their clientele effectively, who are overwhelmingly people of color and people who don't have the resources to hire a lawyer for themselves privately. And so they did something that is, the Supreme Court held 5-4, was a per se violation of the antitrust laws, and the FTC sued to stop them. And they had to, they boycotted the system until they got a raise. And that was held to be an antitrust violation. It was a civil case. No one was going to jail. Nobody was paying damages. But these lawyers were told to stop working collectively to increase their pay so they could do a better job for their clients. And they're not bad people. They just violate the law. And so, my take on this, and one I try to convey to the students in the social justice vein, is sure, it's probably a per se illegal price fixing agreement if you want to look at it through that lens. But why on earth did the 1980s Bush era, H.W. Bush era FTC bother? There's so many cases you can bring in the real world. Why did you bring ones that just beat up on a bunch of borderline legal aid type lawyers who are just trying to do, what's best for their clients and not go broke in the process? So I'm not saying it's right, but the FTC has some discretion, and I would rather them bring cases that help the powerless, not beat up on the people who are trying to help the powerless. And so, in today's world, I'd rather see both agencies, the Antitrust Division and the FTC, I'd rather see them bring a case, if there is one, involving, bread cartels. Like in Canada, there was a very famous case recently involving bread cartels. Everyone needs bread. And if the price of bread is inflated for rich people, okay, that's not great, but they can take care of themselves. But if you break up this cartel, you're really helping the working poor and everyone else who needs bread. If, in contrast, if it turns out there's yacht brokers who are engaged in price fixing or collusion or that kind of thing, that's not great. But frankly, the oligarchs and rich people who buy 500-foot mega yachts can take care of themselves, either through contract, private litigation, or their own antitrust case, and let the government spend their time and resources on things that make for a better, more just world. That's kind of what the mission of the law school, my personal philosophy, is. Now, you asked me a perfectly normal question about the FTC. I had the pleasure of serving for 1 year in 2022 as one of a number of senior advisors, which meant that I was, and several other lawyers, professors who got different kinds of leaves from their schools to spend a year or two with the government. My university was super generous. They just said, we can only do a year, and I said, fine. It started because I called Chair Khan, Lena Khan, who's chair of the FTC, appointed by Biden, to congratulate her because she came into office, I don't remember, around June of 21, maybe July, something like that. And I both congratulated her because I've known her for a while. I'd met her when she was a law student. Actually, she attended this Loyola antitrust colloquium when she was a third-year law student and writing this amazing article about Amazon's antitrust paradox that made her famous at a very young age. So I was congratulating her, and I asked her if she would keynote the 2022 colloquium, and she said it was just too early to commit. She was just getting the hang of the job, and she'd get back to me on that. And then she asked me if I would be willing to talk to some people in their Office of Public Policy, Policy and Planning. And I said, sure. She was kind of like, wouldn't tell me exactly what they wanted to talk about. They just said they were interested in some of my work. And I said, okay, have them call me. And they eventually called me. And in part, they were asking me if I would come join their team to work on a couple of matters that we can talk about. And I had to, get permission from my university, and they were very generous. Once I got we worked out what I was going to do. I got approval in 72 hours from the associate dean, provost, and president of my university to get a 1 year leave to do this. And the president said, we've never done this before. We'll take care of the logistics. If you want to say yes, say yes. And we'll promote you and help you and, keep your job and frankly pay me. So I was essentially an unpaid consultant to the FTC, and I'm not aware of exactly all the different arrangements, but many of the other people were on something similar. Under this administration, unlike the Bush FTC and Reagan era antitrust division, which I knew more about, Chair Khan and the other people she has put in senior leadership positions are really interested in changing the fuel mix of where antitrust aims its attention at. There are just, there's something like 3,000 mergers or so that get notified to the two agencies that they have to do something with. But they also have a great deal of discretion as to what other kinds of cases that they bring or investigate and figure out what they want to do with. And I think Chair Khan has made it clear that she's interested in not beating up on the helpless and the hapless, looking at more powerful firms like Amazon and Facebook/Meta and other, not just large, but really powerful firms. And also look at conduct that harms labor interests. And those aren't the specific things that, that we've talked about, but they're all in the same family of what does it mean to have a progressive antitrust agency that's trying to make the world a better place. And I was thrilled to devote the vast majority of my energies for that year. I had to teach one class that was an online thing that there's no one else who could do it. But other than that, I occasionally worked from here, from Loyola, from my office. but I was working all on FTC matters, and I would go to DC a week per month or so for things that were happening in person, and just to make sure that people were aware that, what I was working on. And my agreement with the chair was I was working on 2 projects, and I can talk about the things that are publicly known about them, and then other things that were sort of smaller things here and there. But we agreed that I would work on a team of people, by no means a leader, who were formulating a proposal that would ban non-compete clauses in employment contracts, which are often abused. And look, me personally, I can't speak for the chair or anybody else, but me personally, I don't care if the president of Sony Pictures negotiates with all their lawyers with the studio to get $2 million more, including a non-compete or something like that. That's fine. I don't particularly care very much one way or another about it. I do care where people who work at Jimmy John's or as janitors or as healthcare providers, like home healthcare aides, who make barely at the minimum wage, maybe $1 or $2 more, who are forced to sign non-competes. Oftentimes after they've quit their other job and sort of shown up for work on the first day, they're just handed a stack of things by HR and or their boss, and just say, sign here. And what is that? Well, you got to sign it if you want the job, and they've already quit their other job. And in one case, and I was working on a rule that has been a preliminary rule that's been published that came out just after I left the FTC. That's still subject to notice and comment. I don't know what the final decision of the commission will be on this, but it prohibited all non-competes in all employment contracts, except for those things relating to the purchase or sale of a business or the formation of a partnership or things like that. And as they were working on this rule proposal, the commission also brought some individual cases against really abusive, oppressive non-competes in these kind of low-paid service industries, where literally, like, security guards and home healthcare workers were barred from taking a job with a competitor if they left for any reason, I think including if they were fired, for like 2 years in a 200-mile zone. So if you were like a security guard, you weren't privy to any trade secrets. You just, man or woman who's doing the best job they can to protect the bank or an office building or something like that. That's your line of work. Why should you have to literally move from like Miami to Orlando or, the rest of the country? It has the overwhelming effect of preventing you from getting a better paying job in the field you're working in, and it takes away all your leverage with your employer. So that's I really was able to work on something that I thought was both good law and consistent with my social justice, economic justice values. And then the other main project that I worked on was the first comprehensive policy statement and I was just part of another working group, trying to define what it means when the FTC Act prohibits unfair methods of competition. And that ended up being I don't remember, 16, 17-page document, probably around 10,000 words, that represents the official policy statement of the FTC, voted on by 4 commissioners. One had already resigned and hadn't been replaced yet. It's a 3-to-1 vote, and it's the policy of the commission, and it's not legally binding, but it provides guidance to the staff, to firms, and to their lawyers as to when the FTC is most likely to care and less likely to care about business conduct that could be challenged under this obviously broad law.
There are a bunch of other questions I want to ask you, but before we switch gears, just staying with the FTC for a moment.
Yeah.
Talk about examples of good leadership and bad leadership.
Well, we all work in virtually everybody works in an organization. Virtually everybody has a boss, right? I'm a short timer at the FTC. Everybody knew I was just there for a year. There was some talk of whether I'd extend for one more semester or not. But, at that point, everybody knew from the day I got there that I'm a professor on loan. I'm going back to the law school. But, there are a lot of people at an FTC. It's about 1,200 people. It's not the world's biggest government agency. like something like the Pentagon is many, many times bigger. So is the Justice Department, because they do so much more than just antitrust work. They do environmental and tax and criminal and all kinds of stuff. I mean, just to give you an idea, the Department of Transportation is huge, tens of thousands of employees. They have probably 1,000 lawyers with probably 25,000 people. Well, whether you work in a law school where, the faculty is 40 or 50 people, the staff is another 100 people or so, and obviously the students, I think good leadership matters. And at one level, it's sort of just a different vector from whether you're a progressive or a conservative. I was thinking of the total. I think I've worked for 8 different deans. I've been associate dean for 2 of them, or 3 of them, I think. And 5 were women, 3 were men, 2 were African American, the others weren't. So I've had all different kinds of ages, genders, backgrounds. One was a former U.S. attorney. Others had just been academics. Some had been deans at other law schools. Some hadn't. So I think the deans and the government, my other bosses, are consistent, truthful, and generally speaking, don't ask you to do anything they aren't already doing or certainly willing to do themselves. Those sound like kind of platitudes, but just in general, those are the things that have resonated with me. And I generally don't knowingly work for people who I think don't measure up. It's always a disappointment if you think someone's not doing the job that you thought they were going to do. But that and to the extent that I was part of the leadership, not of the agency, but of the law schools where I've been associate dean, that's how I've tried to do this. In my view, you want to both inspire and lead and manage. And it's a little weird because most of the professors are tenured or tenure track and are thankfully not doing anything that would result in their tenure being revoked or something like that. But it means like you don't have the same kind of direct, you're not their boss. Right. And what I've learned is, as great as my faculty colleagues are, I'll be replaced. Who can't be replaced? The staff. They don't have the job security. They don't make the same kind of salary structures that professors make, but they are vital to the running of the law school. So to the extent that I've ever been in leadership, I have focused more of my time and attention on the staff side of making sure that the place is running well, because the students interact with us in the classroom, but they really interact with the staff on a day-to-day basis. That's the people who admitted them to this law school, handle their financial aid, provide student services ranging from reserving a room for a pizza party for the Environmental Law Society to an accommodation, a learning disability or other kinds of accommodations on a test, to, for God's sakes, getting a job like the Career Center, study space and electronic and hard copy information from the library. So, I'm persuaded in the law school space that to be an effective manager, to be an effective leader, to run a good law school, that's where the time and attention is. And that's how I kind of approach it. And when I was an associate dean, I tried to be as useful as possible for the faculty, help them if they had an issue, and generally just try to make sure we had the right fuel mix of full-time and adjunct courses. And if we say we're a leader in A, B, and C, that we really have great classes, clinics, co-curricular programs, externships, job opportunities, journals, and so that if we're saying we're Loyola has a very good ranking and reputation in healthcare, just my job was to make sure that that's not puffery, that's like legit. So that's some of the things.
Thanks. Let's switch gears, especially since we've got about 15 minutes or so left.
Yeah.
I want to cover as much ground as we can. AI is something that's on everybody's mind. What do you think about what concerns you about AI from the antitrust perspective? Or, conversely,
Yeah,
So how full, what promises are there for antitrust
yeah.
enforcement with AI?
I have broader societal concerns about the impact of AI than I do about whether it does or does not violate the antitrust laws in a specific context. Both agencies, Antitrust Division, FTC, state attorney generals, are all grappling whether it can be used for or as a tool for competitors to collude. You know, there are plenty of algorithmic ways that they can conspire or collude now that are not technically large language models and machine learning and that kind of stuff. So I think the agencies will get it right. I have a broader concern, which is this. Um, I think any decent law school needs to prepare students for a world where a lot of routine tasks are going to be handled by AI, at least as a first draft. So I was just discussing this with a hiring partner in a law firm. If you had a client like a credit card company, like Citibank or Visa, or issuing bank, and you were or secured lending, you're doing secured lending across 50 states, and they all have minute differences in their laws and requirements and regulations. AI is a perfect tool to generate the one that's Montana compliant and the one that's Illinois compliant to then have a lawyer review for quality control. Or maybe this is more your world, but maybe we're approaching a world where the first draft of patent applications is going to be generated by some kind of generative AI, as opposed to the current system where it's oftentimes outsourced, oftentimes outside the United States to highly qualified engineers. But it's still being done. The first draft is still being done by a person. Maybe it's just an engineer in India or somewhere in the US. And then the in-house counsel or the law firm person is the quality control to make sure it really matches the needs of the client and the patent system, and that it gets through the filing is first rate. And then in the litigation context, I think a whole lot of electronic discovery is going to be subject to already algorithmics and more AI type screenings, because in a big antitrust case or big litigation, no human being can review 10,000 pages in a timely fashion to produce the other side. So somebody or something is going to be screening. And what has me really worried is this has the potential to exacerbate inequality in the profession as well as inequality in the world. And I'd be very unhappy if we end up in a world, and I'm exaggerating at both ends. I'd really be unhappy if we live in a world where partners make $2,500 an hour, and everyone else who's doing the quality control is making $25 an hour or $20 an hour, or even worse. So, I hate that. And those trends are already occurring. And my principal concern, just as a human being, is that it's going to exacerbate that inequality where the strategic thinkers are going to be super highly paid, and the people who are reviewing the results of AI-generated things are being treated as a fungible commodity.
So is the solution then to the technology down, or
Could you say that again, Daryl? I'm sorry, I just missed the last part of what you said.
so the solution to this inequality? A lot of people say technology is the issue. You should sue all these big tech companies, and their algorithms are sucking up copyrighted works and so on. And it seems almost like a Luddite view of saying technology is bad. Let's go back to the Stone Age, which I'm sure is not what you're saying. But then there's the other problem, which is if you want to bring the bottom up, that's a lot more complicated and perhaps less politically attractive than the alternative. So what's the way to deal with this inequality that you're foreshadowing?
I wish I had a magic wand and a magic solution. I don't know, but I mean, I do think we live in a world of increasing inequality in a whole bunch of different ways, and I'd hate this to be just to hypercharge that. You know the statistics about the gap between the multiple between the pay that a CEO gets versus the lowest paid person on the factory line. Compare that from 1950, where it was single digits, to now, which is hundreds, if not thousands, depending on the company. So I like a world where human dignity and human value is a little more evenly spread out. But I don't have a solution. But I do know that there is a tendency for the rich and powerful to be increasingly rich and powerful. And in my area of the law, I have tried to think about how to limit the abuse of power rather than size or wealth by itself. And so that's been the focus. And that's why I was comfortable at the FTC that I shared not 100% congruence with everybody there. And that's, by the way, for people, anybody who's watching, the awesome thing about government practices, there are people of all ideological stripes. I mean, I don't think there's very many people at the FTC who think antitrust laws are worthless and should be like thrown out. But I mean, they're conservatives and they're progressives, and there are people who are hired during Democratic and Republican administrations, and most of them are civil servants. Most of them are not political appointees, and they go about their job no matter who's the chair of the agency and who's president. And they, in essence, they may agree or disagree with some of those things, but they really want just a clear statement of what's happening and what's expected of them and a reasonable workload, and go about their business and do their best job to investigate the things they think are troublesome, make recommendations to the front office, and then litigate whatever is approved, or just be told it got voted down 3-2. Sorry, we look forward to seeing your next case recommendation. There's always another case. So anyway, so I don't think everything is just party politics or ideology. But if I'm going to put my finger on the scale, I'm going to do it on behalf of people who can't take care of themselves rather than the people who already have the keys to the kingdom. And so I'm not worried that a company is large. I'm worried that it's powerful and misusing that power in some important way, either through colluding with other people, the monopolists of the world who can just harm society by themselves, and those mergers, and acquisitions that are going to lead to one of those two problems down the road if we don't stop it. And I think a real test case of that is right now the best example is Kroger Albertsons, something I did not work on, something that was present at the FTC while I was there, and I have no knowledge of anything other than what I read in the newspaper. But right now, as of the date we're talking, the state of Washington and the state of Colorado have just filed lawsuits in their state court under state antitrust law, saying that the two largest supermarket chains, if they merge, will harm their citizens. I personally agree based on what I've read publicly, but I'm not privy to all the facts. And the FTC is deciding what they will do, either on their own or in partnership with other states that are also looking at it. And so in Chicago, I don't know what it is in Harrisburg. In Chicago, it's the merger of the Jewel and the Mariano's brands. And those are the two big supermarkets. And they oftentimes have stores 5-6 blocks, away from each other. And I could imagine a world where if you let them merge, prices will go up. Labor will be hurt in different ways, both by job cuts and diminution of bargaining power and wages and compensation. And other suppliers may be harmed. And I think if you don't block it in its entirety, you have to make big divestitures to prevent that from, coming to pass. And that's how I kind of bring together what I do in the classroom and some of the things I write about and some of the things I think about just as a citizen in the world.
So look back, from the end of 2024, past 4 years, look forward, end of 2024, next 4 years. What were the last 4 years you remembered for, and what do you predict will happen next 4 years with antitrust?
Boy, well, all the impacts of COVID are not going to go away. They represent a permanent change in how we relate to each other as people, and in the economy, and politically, and a lot rides on the November 2024 election that I don't have a crystal ball at all. And despite the fact that elections do matter, and again, it doesn't change everything at these government agencies in the areas that we follow, but it does change fundamental priorities, and elections do matter. So going forward, sure, the AI stuff, the use of antitrust to protect rather than harm workers is a trend I think will survive any political change, because many of these original cases against the tech giants and against collusion that harms labor were initiated in the Trump years or even the Obama years and kind of have moved their way through the system. And yeah, the Biden administration is more aggressive on Section 2 than Trump, but people need to remember that it was the Trump Justice Department and Trump appointed FTC that brought the first case against Google and the first case against Facebook. It was expanded in different ways. So some of these things aren't going to change. And I think the things that matter for me would be how these cases that are designed to help labor in mergers and other areas play out, how the cases against the big tech platforms and other arguable monopolists play out. We didn't talk about it, but I think also how the United States relates to the rest of the world. We do things in a somewhat more laissez-faire, less progressive, less interventionist way than the EU and other countries on antitrust area.
Is that good or bad?
I think we can learn a lot from the rest of the world. I think we've been asleep or partially asleep for 40 years, and that the last few years have been a breath of fresh air that I'm glad to be a really itsy bitsy little part of. So those are the things that I can predict in our fields. But again, I'm not in the political prediction game. 2016 was not a good year for political predictions by me or other people.
Thank you. As always, a pleasure to speak to you, Spencer. Thank you for taking the time to join us on our Profiles in Leadership series, for your service in so many capacities at Loyola, at the FTC, Lawyers for the Creative Arts, and many other things, including, which we didn't get to, your contribution to the theater and the arts.
Well, thank you, Daryl.
Do you want to say that as a last note before we sign off?
Sure.
What can we look forward to?
Yeah, it's both life outside the law, but also a little bit inside the law. My wife works in marketing in Broadway and touring Broadway theater, and as a result, I've had a chance to enjoy many, many plays, but also as a result of learning more about that industry and just consuming, theater, which I've always liked. I'm writing a book right now about competition and collusion in the American theater, and since the end of the Civil War, most of live entertainment in the United States, popular live entertainment, Broadway, touring Broadway, vaudeville, when that was a thing, have been dominated by collusion and by cartels and monopolies of the kind we've been talking about, and they're not that well known. Today, to the extent people know much about it, they may have heard of like Ticketmaster and Taylor Swift, and that's important. But there's a whole history of that, and I want to lay that out and explain why it still matters today. And then I'll give you a scoop. Also in large part through the connections and professional interests of my wife. She and I are going to be among a group of co-producers of the revival of the Broadway musical, The Who's Tommy, which premieres sometime in March of 2024. That just means we're a small number of people who've been involved in the raising of money to make that possible, not the artistic people who are making the choices of how that show will be presented. But it's an awesome show. And although I have a vested interest in it being successful, I hope people will take a look and decide for themselves if it's something they'd enjoy watching.
Wonderful. Where can they watch the show? Where can they get the book?
The book, probably I'll need another year and a half to finish it and hopefully find someone to publish it. You can purchase tickets for The Who's Tommy on Broadway. I believe it's available as of the time we've recorded this. If not, they're going on sale very, very shortly. And if things go well, it will run on Broadway for a good long time, and hopefully tour the country. In which case, I don't know, because none of that's been set yet. But it would normally tour for a year or two if there's enough demand, starting in like the biggest cities for weeks at a time, and then gradually to smaller markets for a week or sometimes half a week as it makes its way around North America. And
like you, might find its way to Chicago.
It's almost inevitable that any, if successful, tour will include Chicago. Hamilton has been here multiple times. Plays like Rent from 30 years ago, more modern things that I have no involvement in one way or another. There's a play based on the movie Mrs. Doubtfire that's playing somewhere downtown. That's part of a national tour. So these are the things that are often presented in these theaters. in Best of Broadway series. So like there must be one in Harrisburg where you're getting the national touring productions of both dramas, comedies, and musicals. So that's some of the stuff I'm talking about in the book. And then this is just a very minor way of putting an academic interest into real life.
Thank you. Yeah, Harrisburg is about 30 minutes away from where I am, but not too far. It's certainly in the airport I fly out.
Yeah, so go see a Broadway musical if it speaks to you.
Thank you. And
Thank
thank
you
you
for
again
having
for
me, Daryl.
joining us.
Oh, my pleasure.